Near the end of his first year in office, President Andrew Jackson announced that he wished to see all Redskins living east of the Mississippi expelled into the Great Plains. Indian removal had been a platform policy Jackson had campaigned heavily upon, and he was preparing to introduce his first major piece of legislation as our seventh president. 6 months later, in 1830, Jackson signed his controversial Indian Removal Act into law. The act had narrowly passed in the House by 5 votes. In carrying out the policy of Indian removal, Jackson and all of the presidents and Congresses since have rejected 2 majority opinions of the Supreme Court issued within a year of the Indian Removal Act. First, in 1831, Cherokee v. Georgia, the court decided the tribes were domestic dependent nations with a relationship to the United States like that of a ward to its guardian. Chief Justice John Marshall, writing for the majority, stated that the federal government inherited the rights of Great Britain, and those rights included the sole right of dealing with the Indian nations, but not the right of possession of their land or political dominion over their laws. The court basically said, we must honor the treaties made with the indigenous tribes. Second, also in 1831, Georgia v. Worcester, the Marshall Court decided that states have no criminal jurisdiction in Indian country. This ruling laid the foundation of tribal independence in the United States and contradicted Jackson's earlier statements that Indians who refused to be removed would have to abide by state laws. Jackson not only spoke and acted about his insurrection, he went so far as to put it in writing. Clear evidence of this exists in his formal message to Congress and the Supreme Court that accompanied his bank bill veto. In it, he suspended judicial review that had been established 3 decades earlier in 1803 in Marbury v. Madison. Jackson denied that the Supreme Court had any authority over him, or Congress for that matter. Jackson wrote, "The Congress, the executive, and the court must each for itself be guided by its own opinion of the Constitution. Each public officer who takes an oath to support the Constitution swears that he will support it as he understands it, and not as it is understood by others." This statement is clearly a slap at the authority of the judicial department of the body politic. Jackson went on to write, "The opinion of the judges has no more authority over Congress than the opinion of Congress has over the judges, and on that point the President is independent of both." This declaration by Jackson is nothing short of imperial tyranny, and it is not how our 3 branches of government were designed to operate through a series of checks and balances. Jackson got checked, but he never got balanced. In fact, he has been attributed with saying, "The court has rendered its decision, now let's see them try and enforce it." Jackson's 1832 message also stated that the authority of the Supreme Court must not be permitted to control the Congress or the executive when acting in their legislative capacities, but to have only such influence as the force of their reasoning may deserve. This last sentence relegates the Supreme Court, the law of the land, to an advisory body with no ability to enforce its findings or orders. Clearly, Jackson considered the Constitution of the United States to be an advisory document as well. Not only should the patently offensive Indian Removal Act of 1830 be subject to judicial review, it must be reviewed, and very likely repealed. It may be unfair to judge 19th century thinking in the 21st century, but frankly it is self-evident that any law that suggests the removal of an ethnic group is going to be violating someone's natural human rights. Now, this may all seem like ancient history, but the removal of Indians from their ancestral lands and the reclamation of that land by the Interior Department is still going on today. As one example, in 1981, a lawsuit was brought by the Sioux Indians seeking to recover 7.3 million acres of their sacred Black Hills, as promised by the Treaty of Fort Laramie in 1868. In the preceding case of United States v. Sioux Nation in 1980, the Supreme Court offered monetary relief but not title to their lands. The Indians have never accepted the cash. It is worth noting that Associate Justice Blackmun, writing for the majority in the case, castigated the government's dealings with the Sioux by stating for the record that a more ripe and rank case of dishonorable dealing will never be found in our history. Sadly, Justice Blackmun was being far too optimistic, for past and subsequent history has proven him wrong in his assessment of the character of Congress and the Bureau of Indian Affairs. Even more recently, the Justice Department has been forced to settle claims totaling billions of dollars directly attributable to the theft and mismanagement of Indian trusts by the Bureau of Indian Affairs, and there are dozens of other claims pending. Over the past 3 years, researchers in the Tecumseh Federation have pored over hundreds of historical writings, legal documents, speeches, books, and hours upon hours of video documentaries, seeking to uncover the true history behind the U.S. Congress's odious Indian affairs policies. The result is that we are of one mind in believing that the failure of Congress to acknowledge that it had conspired and colluded in an insurrection over the Supreme Court to pass the patently unlawful and immoral Indian Removal Act is the sole reason for the continuance of America's killing fields today. The federal government's failure to grant fee simple title to the Indians is at the root of all the catastrophes surrounding America's wretched Indian affairs policies. The removal policy created the modern-day BIA reservation system, which we now know to be institutionalized genocide, with mass exodus by those who can, and the erosion of an entire culture that helped define the Western world. America's killing fields are a can of worms that nobody wants to open. These truths represent for many the darkest blight in our nation's history since passage of the 13th Amendment abolishing slavery. But our generation and the ones that follow must have the courage to open old wounds if we are to meet the promise of America to its people today. Let us mourn, grieve, and acknowledge our forefathers' errors and wrongdoings and attempt to make things right for our country's first people, the Native Americans.